This is the unanimous judgment of this court. It's a judgment prepared by my colleague Nafsa, the acting deputy president. The matter arises out of the withdrawal of certain criminal charges against the appellant on the 1st of April 2009. It deals with the history of the litigation that has happened surrounding this matter. It is not my intention to deal in detail or to read the whole judgment, which is some 47 pages in length. I can indicate that there was a finding of a full bench which was came on appeal to this court, and at paragraph 94 of this judgment, the case was summed up as follows. The case presented by the NPA, principally through Mr. Hofmeyr, was that Mr. McCarthy's conduct in influencing the timing of the service of the indictment so that it occurred after the ANC's Polokwane conference was so egregious that it amounted to an abuse of process to justify a discontinuation of the prosecution. This was based largely on conjecture and supposition. The allegations by Mr. Hofmeyr of political machinations on the part of Mr. McCarthy were irrelevant because they were unconnected to the integrity of the investigation of their case against Mr. Zuma and the prosecution itself. The authenticity and legality of the recorded conversations which Mr. Mpashe considered vital to his decision to discontinue the prosecution are not beyond doubt. Since the recorded conversations were considered vital, greater thought ought to have been given by the NPA to these issues. The manner in which the affidavits were drawn and the case conducted on behalf of the NPA was inexcusable. The reasons for discontinuing the prosecution provided by Mr. Mpashe do not bear scrutiny for the recordings themselves on which Mr. Mpashe relied, even if taken at face value, do not impinge on the propriety of the investigation of the case against Mr. Zuma or the merits of the prosecution itself. Even if one were to accept that Mr. McCarthy had his own ulterior purpose for having the indictment served after the Polokwane conference rather than before it, what is indisputable is that it was in any event not practically possible to have the indictment served before the conference. There were nonetheless sound other reasons, such as the stability of the country, accepted as such by both Mr. Mpashe and the Minister of Justice and Constitutional Development, that dictated service of the indictment after the Polokwane conference. In the circumstances, Mr. McCarthy's alleged motive in relation to the timing of the service of the indictment was ultimately irrelevant. The submission on behalf of the NPA and Mr. Zuma that Mr. McCarthy had a central role in the timing of the service of the indictment is at odds with the contradictory account provided by the NPA in relation to who had made the decision about the timing of the service of the indictment. Mr. Mpashe had told Mr. Downer that the timing of the service of the indictment had been his decision alone. In a supplementary affidavit, he explained that he had been untruthful in that regard in order not to bring Mr. Downer under the impression that he had been influenced by the Minister of Justice and Constitutional Development. That explanation itself impacts negatively on Mr. Mpashe's credibility and on the soundness of his decision to discontinue the prosecution. The exclusion of the prosecution team from the final deliberations leading up to the decision to discontinue the prosecution appears to have been deliberate and is in itself irrational. The case law that formed the basis of Mr. Mpashe's decision to terminate the prosecution does not in fact support it. On the contrary, the cases, including an appeal court decision overlooked by Mr. Mpashe, are to the effect that questions of abuse of process in relation to a prosecution should be decided by a trial court and not determined by way of an extrajudicial pronouncement. In his media statement in which he provided reasons for terminating the prosecution, Mr. Mpashe referred to the following dictum of this court in Zuma, and I quote, "A prosecution is not wrongful merely because it is brought for an improper purpose. It will only be wrongful if, in addition, reasonable and probable grounds for prosecuting are absent. something not alleged by Mr. Zuma and which in any event can only be determined once criminal proceedings have been concluded. The motive behind the prosecution is irrelevant because, as Schreiner J.A. said in connection with arrests, the best motive does not cure an otherwise illegal arrest, and the worst motive does not render an otherwise legal arrest illegal. The same applies to prosecutions. However, he missed its true meaning and import and misapplied it. In the circumstances set out above, Mr. Mpashe's stated purpose of preserving the integrity of the NPA and advancing the cause of justice can hardly be said to have been achieved. The opposite is true. Discontinuing a prosecution in respect of which the merits are admittedly good and in respect of which there is heightened public interest because of the breadth and nature of the charges and the person at the centre of it who holds the highest public office, can hardly redound to the NPA's credit or advance the course of justice or promote the integrity of the NPA. Regrettably, the picture that emerges is one of Mr. Mpashe and Mr. Hofmeyr straining to find justification for the termination of the prosecution. Thus, the conclusion of the court below that the decision to terminate the prosecution was irrational cannot be faulted. In reviewing his own decision to institute criminal proceedings against Mr. Zuma and ultimately making the decision to terminate the prosecution, Mr. Mpashe wrongly invoked and relied on Section 179(5)(d) of the Constitution and on Section 22(2)(c) of the NPA Act. These provisions deal with the review by an NDPP of a decision of a DPP and were inapposite. Thus, the concessions on behalf of Mr. Zuma and the NPA that on that basis the decision to terminate the prosecution was liable to be set aside was rightly made. In light of what appears above, it is difficult to understand why the present regime at the NPA considered that the decision to terminate the prosecution could be defended. The appeal must therefore fail. The DA sought the cost of 3 counsel, which in the circumstances of the case is not without warrant. The NPA and the President made common cause and should be liable for the DA's costs jointly and severally, the one paying the other to be absolved. The following order is therefore made. 1. The applications for leave to appeal are granted. 2. The appeals are dismissed with costs, including the cost of 3 counsel and the costs related to the applications for leave to appeal. The National Prosecuting Authority and Mr. Zuma are to pay such costs jointly and severally, the one paying the other to be absolved. I hand down the judgment.
Judgment in the matter between E.H. Hassan Hardware and Farrakhan CZ.
This is a judgment of Molamela AJA, with whom Shongwe AP and Fourie AJA concur. The order is as follows. 1. The appeal succeeds with costs. 2. The order of the court quo is set aside and replaced with the following. The application for rescission of judgment is granted, costs to be costs in the cause. 3. The appellant is directed to file its notice of intention to defend within 7 days from the date of this order. Does that conclude our business? This court will now adjourn.